online on our YouTube channel. So welcome. This is the second lecture, really close after the first one, because we had to pack in so many great speakers in our Unsettling seminar series. This is organized by the Decolonisation Group, which is an initiative that has been set up at Utrecht University. Rachel and myself are very active members of that group, but we have a lot of other people as well who set up events and drive a lot of what we're doing. It is first and foremost a collective attempt to reflect about decolonization as a historical event, but also as a societal phenomenon and as an issue in teaching. Those are our three sort of pillars that we want to put forward. And this conversation that we're organizing here with the general public and with students is part of that effort. Today we're going to talk about ways to unsettle law, maybe even decolonize law, what that might mean, what that might look like. And we have the distinct honor of having Alison Fischer and Nawal Mustafa as our speakers. They are both PhD candidates, but they are already producing so much interesting ideas that I think it will be really worth our time listening to them. Alison Fischer was very gracious in already saying yes to the first seminar series that we had organized, which was a real life event. And then we asked her back, and she said yes, and then we switched her around. And so I want to thank you so much for still saying yes. Alison Fischer is a PhD candidate on the subject of law, race, and post-colonial communities in the Netherlands. She's at the Royal Netherlands Institute of Southeast Asian and Caribbean Studies, which in itself is a very interesting place to work at, particularly considering the work you are doing. And Alison already told me that she's going to reflect on this a little bit. Nawal Mustafa is also a PhD candidate, but at the Free University of Amsterdam. And she studies, she's analyzing the topic of the lives of Black nurses in the United Kingdom from 1949 and 1970. And she's looking at something very interesting, which is part of a bigger project at the Amsterdam Center for Migration and Refugee Law. She's studying a sort of segregation. She's studying segregation practices in Europe, which is as a practice that wasn't only something that happened in the U.S., which I think is, amazing topic. So I'm gonna give the floor to both of you now. Thank you so much once again for wanting to speak to us.
Thank you. I'm going to try and share my screen here. Does that work? Can everybody see that?
Yes.
That means I can't see all of you. So if anything goes wrong, somebody app me.
We'll shout. We will.
Great. Well, Nawal and I had talked about sort of just introducing ourselves and our work and a few of the challenges we face, and then hopefully having as much discussion as possible. So that being said, Nawal, why don't you go ahead and start?
Yeah, so I think a lot of it has already been said. First of all, I would like to thank Alison and also the organizers of the meeting today for inviting me and including me in this lecture series. So my PhD research, I started off focusing on Black nurses who arrived after around 1950s, 60s to the metropole UK to work in the then newly created NHS. However, the main focus of the project that I am in is the regulation of interracialized intimacies or interracialized relationships. And so I say interracialized because language matters, and it's important to be as precise as we can. And even though the project is talking about race and sort of using these categorizations, by calling it interracialized, what we would like to communicate and I would like to communicate is that these there is not necessarily a mixing of blood or a mixing of whatever. They are interracialized because the community or the wider society perceives these people to belong to different races. Therefore, they become interracial or interracialized, in my view, and that relationship, because the gaze of the wider society and the way they're perceived creates this interracialization. right? So that is the broader project. So and a couple of the choices that I made is so it's a historical empirical legal study in which I look at archival materials. I started off by looking at I wanted to look at experiences of Black women because they are excluded from the archives, and ended up looking at nurses. But then I shifted away from that, and I'll go into that later on. So I'm predominantly working on my PhD. I hope I'm almost done. I still have a year and a little bit more than a year to go. So the intersection that I work on is race, history, and law. And I have a specific gendered intersectional perspective on how to approach it. Other than that, I am involved with several grassroots activism in the Netherlands that deal with anti-racism or anti-Muslim hate or Muslim discrimination. One of the initiatives is Speak. For those who are interested, is a collective that we, together with other women, I initiated. In which we have this more feminist and anti-racist discourse and a basis, basically, in order to address inequalities and racism Muslim women are facing in the Netherlands. So that's what I do next to my PhD, and I'll leave it at that for a minute.
I think that's a really nice transition. To back up a second, it's really fun to be doing this with Nawal, even if I can't see her at the moment. And I think when we envisioned it, I envisioned us sort of sitting next to each other because we've been discussing these things as friends and colleagues and in different perspectives for the last 4 or 5 years or so. And so while she is towards the end of her project, I'm at the beginning of mine, but it's really the fact that I'm able to be at the beginning of a PhD project has a lot to do with the conversations we've had in the past couple of years, and also conversations with Rachel and folks at the Decolonisation group. So it's really nice to be here. Both Nawal and I are what I guess you could call non-traditional PhD students, in that we both had careers before. And one of the things we talked about in preparing this lecture was how those careers and really our sort of, especially our experiences in grassroots movements and grassroots movements for equality and justice, particularly racial justice, have informed our PhDs and informed the privilege that we have as sort of non-traditional students as saying, this is something that's really important for me to research. And these are both voices and perspectives that it's important to bring. And having a little bit of the, I guess, sort of age distance or something to say, I'm going to be able to sort of force this agenda, or not agenda, but perspective into what I want to research. So in that way, I feel additionally privileged to have a really odd PhD position at the Royal Institute for South Asian and Caribbean Studies, which in Dutch is the Koninklijke Instituut voor Taal, Land en Volkenkunde, which sounds very old-fashioned because it is. I think the KITLV was started in 1851 as really the Colonial Research Institute for the Netherlands. So their mission was to create academic knowledge to help manage the colonies, basically. In the last 10 years, the KITLV has done a lot of reevaluating of that legacy and trying to pay more attention, not just to studying the colonies, but also studying the impact of colonialism on various aspects of Dutch culture. So to that end, about a year ago, they put out a call for my position, and I quoted here from the employment advertisement, which was a PhD position to understand the nature and impact of colonial legacies in areas that have been part of Dutch colonial space. And the way the call was written, it was really clear that Dutch colonial spaces or post-colonial spaces were envisioned as being elsewhere than in Europe. It was things like expertise in Indonesian or colonial languages is a plus, and all those things are completely legitimate and a plus. But my pitch was, look, the metropole, the European Netherlands, is a Dutch colonial space. It's a post-colonial space in that it's a space where colonial dynamics and colonial practices are still having an impact on present-day society. So that's one way. And I think Nawal and I will talk a little bit more about decolonization versus decolonial, post-colonial versus being a position in time to sort of an era in which the colonial legacy is still functioning. So to that end, I'm looking at Dutch university law faculties and legal teaching as a colonial space or post-colonial space, and how that teaching either contests or recreates these sort of colonial dynamics. This fits in really nicely with my history as an organizer, which is mostly on issues of access to higher education. So it's a nice continuity there. One of the things we thought we would touch on, if that's a good place to switch, is one of the challenges of doing this kind of work in a legal, in the legal frame. Both Nawal and I think it's interesting. I'm funded by the KITLV 100%. One of my supervisors is at the Leiden Law School, so I have a little bit of overlap there. And Nawal is at the law school at the FU, but both of us were saying that we are actually some of the few lawyers, even within the law school, working on these kinds of issues. Is that right, Nawal?
Yeah, so just to continue on that note, so I'm at the Center for Migration and Refugee Law at the Vrije Universiteit, or migratierechtssectie. And so the interesting thing is I am a part of a team of 6 people. Of the 6, 2 are legal scholars. One is the PI in the project, Betty de Hart, and the others are all anthropologists, more in the social science and history. And my experiences so far has been that the black letter lawyers or legal scholars have a difficulty in understanding what we're doing and how can you research what is the relationship between the law and race, and how does that, and there is this perceived notion of the neutralness and objectiveness of law, right? So then, and we come in, Alison in her function and I in my function, and say, no, we're legal scholars. You cannot push us aside because we're social scientists and we don't understand the law. We actually understand the law and we work with the law. At the same time, we also have a lot of critique on the law and how the law is being taught, how the law is being practiced in the Netherlands. And I think it's a blessing and also a curse maybe in the same time, because I see a lot of possibilities, especially doing empirical study where you take the law as a serious field of study. Because I perceive it as a field of study, and I'm not necessarily interested in only migration law or international law or private law or whatever. I'm interested in the position that the role and positioning of law and legal scholarship in general. And I think that's something that we also have in common. And to continue on the discussion about decolonization, decoloniality, and so on, I think for me, a starting point is what if we talk about decolonizing something or decoloniality, what do we mean? And in order to sort of understand what the group also understands under these concepts, I took a look, I was reading through it, and I find sometimes decolonization and decoloniality being used interchangeably. And I think they're not necessarily interchangeable. I don't necessarily agree with that way of conceptualization, because one is the formal ending. For me, decolonization is the formal ending of the colonization of former colonized countries and so on. And so the formality, it's an event that happened and it continues to happen. So I'm not saying that is necessarily over, because you can critique it on different matter. And I think it's also important to do research on that. But the other thing that I am interested in my project, and I think one of the reasons why I'm focusing on the metropole in the UK in my case, is because decoloniality, as I understand it, is a process and a structure of power dynamics, and I think of restructuring and challenging power dynamics, right? So in order to do that, you also have to go to where the power is. And when I started my PhD, I was thinking about, where do I look at? And it would have been easier for me to choose a country that was colonized by the British. And I actually looked at the map and I was like, okay, so I can do whatever I want. I can actually basically go to any country and do a case study. But I wasn't interested in that, especially because also being a lawyer from the Netherlands, being educated in a very Eurocentric and very legal positivistic view of law, I did not want to do that. So I kept it at closer to home. I'm from the Netherlands, so Britain is definitely not home, but the metropole, so where the power is. So that has been my starting point to look at, okay, when we talk about decoloniality, we also have to reckon with the center of power, right? And we have to look at the center of power and how colonial discourses traveled between the previous colonized countries, but also how they influenced the metropole, and the other way around, right? So I don't think it's not racist discourse or legally embedded racist discourse is created in the countries that were colonized. But I think there is a lot to be said that they were also created in the UK, and they influence each other and they co-created each other, right? So I was more interested in that, and how does the center of power view race and law, and what is the role of law in that? I'll give it back to Alison.
Yeah, I just want to jump in with a definition, because I know a lot of people, I don't know who is in this discussion. That's one of the challenges of being online, but to define terms a little bit. I mean, one of the challenges of doing decolonial work within a law school is what we identify as the dominance of legal positivism. Mm-hmm. And what that is for people who work outside of law schools is legal positivism is like, what is the law? The mm-hmm. law being defined as the law is what legislators or lawmakers call it. It's the law written down. And how does that law apply to the facts at hand? So if you were to go to a law school, I would venture to say most places in the world, that's a dangerous thing to say in a group like this, but certainly in Europe and the United States, but I think also in many of the places colonized by European countries, and you were to go to law school, the vast majority of your education would center around finding what the law is in law books and learning how to apply that law to a given fact pattern. Right, Nawal, that makes sense?
Yeah, definitely.
And that is basically what students are taught very early on, is doing law and is lawyering and is the appropriate discussion to have in a law school setting. So if students might try and come in, and then you hear these bizarre stories from law schools where like a professor would say, well, let's debate this contract over the sale of an enslaved person. And a student might say, well, shouldn't we discuss whether slavery is a just institution at all? And the professor would be like, that's not law, that's politics, or that's history, or that's morality. Like, be a lawyer, just think about the legal question. And so this is this kind of domination of legal positivism. And a lot of legal research is sort of identifying different variations of legal positivism and different fact patterns, and really coming from this place where it's assumed that if something is law, it is legitimate, and making decisions based on the law and applying it to facts is sort of the box of legitimate legal decision-making. So we've sort of visually represented that by making it big on the left-hand side of the slide. Mm-hmm. And the right-hand slide are all these other also very legitimate ways to think about law. Critical race theory and third-world approaches being something I'll explain a little bit more. And Nawal just went into decolonial theory and decoloniality. But I think this is some of the challenges that we come into, and why it's probably not so surprising that we are sort of in the minority being trained lawyers who are approaching things from a historical or critical perspective. I should say in the minority in the Netherlands. There are definitely lots of critical legal scholars in other parts of the world, but that's another discussion. So I just wanted to, and that's actually part of what I'm studying, is how this perpetuation of legal positivism in legal teaching just kind of tends to reinforce this coloniality as opposed to challenging it. In a sphere where people are really going to go out and impact the world, because that's what lawyers do, right? They affect whether you, were discriminated against at your workplace, or whether somebody gets arrested, or whether contracts are valid, or all these things that have a very valuable or very material impact on people's lives. So that being said, I think part of a transition is this visual. The visual is something I came up with, but basically to explain an article by someone Nawal works with, Betty DeHart, who places what she calls the legal archive as within the bigger cultural archive. So a way of thinking about law within the way we think about culture and society. And that being the ways that sort of we refer to law to identify the values of society. And you see that a lot in discourse, like, especially I think when you talk about the vrijheid van mening in the Netherlands, like people are really talking about a legal protection from being curtailed by the government in certain speech patterns, but this is now part of like the culture of what it means to be Dutch, right? So this is one of the ways the legal archive fits into the cultural archive, but also that when we look at the legal archive, and when I say we now, I guess I mean more critical scholars, we are not just thinking about legal documents or statutes or court records, but we're also thinking about, we are looking at those things. Those things can be good sources of historical material and information, but also looking at how these sort of unwritten facts or feelings about law can also influence legal decision-making and material impact on people. And a lot of times you see that most obviously, I should say, in law that centers around regulating family and marriage and child custody, like the Wealth Project is working on, certainly around migration law and border law, and a lot of times around criminal law. This isn't the only place where you can find the sort of influence of coloniality, but it's three of the bigger places where it happens. Did you want to add on there, Nawal, or do you want to go into your project?
Yeah, I think maybe just to explain or maybe dive a little bit deeper into what we understand the law to be. It is indeed broad, but I think one of the anchors of how we approach the law is that the architecture of the law is always dependent on a specific epistemological location and is implicated in power. So
Yes.
a proof thereof is, so it can never be neutral or objective, and it can never have neutral or objective consequences. It is always, so one of the things that we want to challenge in the project that I'm doing with Professor De Hart is this notion of we never, so the intimate space relationships are often seen as something that is private. That is debatable. That I'm not even going to go into that. But so we take that as a given. Let's say we take that as a given, but at the same time, so it's something that is private, but the assumption is also that it is not regulated. It is regulated in many different ways. So it's regulated, even if you want to get married, it's regulated. If you want to live together, you also have to do all of these legal actions. So that is one side of the way our personal and intimate relationships are influenced by lawmakers and legislators and so on. The other way is when we look at interracialized relationships is that one of the ways that it is one of the assumptions in legal scholarship in Europe generally is that we've never segregated along racial lines. That happened in the UK where the Loving case is really a good and an important example of. We mentioned apartheid South Africa, right? And we also say, oh, by the way, during the Second World War, indeed, Jewish people were not allowed to marry others. So then we admit that there was regulation in the intimate sphere in that manner, in that way, but not along racial lines, right? So, and we think that in our project, the premise is that, well, we did regulate, but we did it differently. We did it through maybe policy. We did it maybe through, it was in an indirect way. And that's also how the law works. So we look at the ways in which, and we approach regulation as we use the concept of regulation instead of the law in itself, because regulation can be broad. It is also actions. It is also policy. It is also, and those actions and policies can also be positive or negative. In case of family law, some current family law, sometimes some people are encouraged to bring a partner over and others are not encouraged. So those are also actions that we take into account. But also we look at embassy, for instance, we look at church records, we look at all of these different sites that don't necessarily feel as law or impacting the law, but which we claim do impact law formation and how a societal problem is then legalized or institutionalized, right? So that's one of the things that I think the legal archives, when the legal archives comes into being. So we don't look at the law. We do look at the law as it's written, the formal laws, but we look broader than that. So we look at, it's maybe an onion. So that is maybe the heart of the law is maybe the formal, but that didn't come out of nowhere. It came into being through processes, through information gathering, through all of these other actions. So we also include that in the legal archives to sort of make sense of how this law, specific law, or how for instance, in my project, what I came across is seemingly neutral and objective laws do regulate. For instance, Rent Act in the UK is used to regulate mixed interracialized relationships. So how that is not a law that was meant to regulate interracialized relationships, but it does. So those kind of things that are things that fall within the legal archive.
Is that a really nice transition to a little bit more about your project?
Yeah, okay. Okay, so my project, as I was saying, is about, I call it the ambivalence. I don't know if this is a working title, so maybe it will change. And that's the last thing that I need to worry about, I think. So it's about, I think I'm interested in how race sometimes is ambivalent in Europe, right? So it's sometimes it has so many different meanings. Sometimes it uses a cultural articulation. Sometimes it uses religious. Sometimes it uses phenotype and race as biology, right? So all of these things it's so interchangeable, and because it's not a concept that you can grasp easily, it can mean different things simultaneously. And law, similarly, I think law has been too innocent for my liking, and the implication of legal scholarship has been too innocent. I was telling Alison yesterday that anthropologists have come to reckon with their racist legacy of measuring skulls. I don't think legal scholarship in Europe specifically has come, and especially in the Netherlands, hasn't really reckoned with their past and implication of producing racialized and helping institutionalize race or racist regimes. So my project focuses on the metropole in the UK. I centralize Black women because in the archives and the academic literature available on mixed race studies or critical mixed race studies does not say anything about Black women and how they experienced interracialized relationships or how they dated, so they come across as women who so on the one hand, they're hyper visible because they were nurses and they were in the care profession, right? And they were also working in the transportation, and they were visibly they were in the society. However, when it comes to the intimate sphere, all of a sudden their experiences seem to not matter are less policed. So I think this is interesting on different levels. On the one hand, I don't necessarily see this as something negative, because I think invisibilization can also be a productive space. So that means that they could maybe have relationships outside of the gaze of society, outside of the gaze of the lawmakers and so on. So that is one thing that might be positive. The other thing is I think it might be interesting to focus on Black women, because we can also see how white women and the obsession with policing the sexuality of white women and Black men is particularly harmful to white women, and it's also part of this construction of nationhood, and how do we have a specific outlook on what our nation should look like. How can we reproduce that through the bearing of children, which is already a huge problem and something that's in the news in 2021, unfortunately. So that is one of the reasons. So I look at archival material. I have an example of the archival material that I come across in the archive. So it's a huge text. Take time. I'll walk you through it, but feel free to read. So this is an excerpt from the archives, from the Metropolitan Police Archive, and this is a response of a police chief in a specific neighborhood in London. That is responding to questions from the town clerk. So a specific town clerk in the borough of Lambeth was interested in conducting information about the colored community. That is what they were called. So the language that I'm using is not necessarily mine. I just want to put out there. So when I say color, this is all I try to use to communicate to you that this is not my language, but this is the language that was being used back then. So he asked for information about the colored community, and he had 5 points. Two of the 5 points had to do with social disturbances and fightings between white men and Black men. And the social disturbing had specifically to do with who gets to engage with who. And this the reason why the town clerk was asking these questions is because the people who lived in a street in his borough complained about a house that was being rented by colored people, and they said that white women are always coming in and out of that house. They had all of these complaints about it. It was noisy, it was not clean, this and that. So then the town clerk, took it upon himself to ask everyone, every borough, every police chief, and I think there were 10 or 11 different police chiefs that reported on his request for information. So they all responded, and many of the responses are similar to this. So they would say, so when it comes to social disturbances, they talked about young white women engaging with black men, and black in this sense it also includes people from India and Pakistan. So it was a more broad. Everyone who wasn't white was black. So they say they report that white women, but interestingly, the white women who are there are already cast outside of the society, right? So they are either women of low morals, mere sluts, or low prostitutes, right? The low type of prostitutes. So they already become, by association, they transgress. Therefore, we are pushing them out of the acceptable society. So that is one of the things that I come across. And this is the police reporting on this. And many of the police officers also gave advice on how to deal with this problem. The other thing that you can read is how what kind of stereotyping is used surrounding the men that are being addressed. So their intellectual capabilities, as well as their conduct in work, is all questioned, and there is this whole notion of the white police chief reporting. If you read it, you can see how superior he feels and how superior the white race in this case is. And it's interesting because who is the white race? White women who engage with them certainly don't really belong to the white race, because they become all of these, they get name called. So I couldn't include that, but one of the things that is also mentioned is that if they invoke the lack of availability of black women. So they say if there were black women living in large numbers in the UK, in London specifically, then these men would not engage with these white women. So the only purpose that black women in this case have is to sort of the whole notion of a race will only date within a race, that is being perpetuated, right? So that's something that they think will happen. Nobody is thinking about what do black women want. Would they want to date black men, or would they not? There is no option. So they have a specific role to play in this construction of race and policing in that way. So the police would surveil houses. They would collect information. They would check how many white women were entering a house and leaving a house. Even if the woman is not a prostitute in the sense of exchanging money for sexual favors, she would be categorized as a prostitute. So these are the things that I came across. And how does it link to the law? It links to the law because all of these police, these reports were conducted in 1955. So after that, all of them suggested the restriction of migration, the restriction of immigration. And in 1962, after the riots of 1958 in Notting Hill, London, the first Immigration Act was the Commonwealth Immigration Act was introduced and enacted upon. So it actually had consequences, right? So this information is used in order to justify the restriction policy that the UK used. The immigration laws in themselves are really highly racialized, and there has been a lot written about it, but not the connection to interracialized relationships, and that being one of the reasons why they were introduced. And that is something that I'm interested in.
Really nice. Really good sort of transition to mine, because I think a lot of what I am looking at, and I know those of you at the decolonial group, I've used this slide before because this just keeps coming back in my head. I think one of the things that happens when we talk about race in Europe is this erasure of the dialogue about race. And from a legal perspective, and this is my Americanness coming through, we use this phrase a lot in American civil rights law, talking about de jure discrimination, which is just great Latin for being like in law, and de facto discrimination being in fact. And so when I look at Dutch history, I see this line, not coincidentally, around 1945, where this de jure racialization. So when we have these very explicit laws which address race, create race, construct race, regulate race, sort of openly and unabashedly, disappear. And yet, as Nawal said, we continue to see common racial knowledge, as some people talk about it, or stereotypes, or even also blatant racism influencing then deracialized family laws, migration border control laws, in-birthing requirements, things like that. So this fingerprint that goes from sort of being clear fingerprints to blurry fingerprints has always been something that's interested me. At the same time, I think what's always interested me is education and the way we transmit the knowledge of this sort of history in the legal context. So that's what got me thinking, okay, when we're looking at lawyers, Nawal and I started our presentation by sort of saying a problem with legal academia is this insistence on a lack of context, or an insistence on color blindness or objectivity that doesn't seem to exist in fact. So how does that happen? And that got me thinking about how it happens in the sphere of legal education. So what I started thinking about is what happened in law schools, what happened in the way we were teaching law around this dotted line period, right? In this period where we start transitioning from, fully teaching, and actually just to back up and give some context, Nawal, you were talking about how we think of families as not being regulated by explicit laws about race. Yeah, after 1945, definitely. But I was thinking about, some of the laws about racialized citizenship that had existed in the Dutch Empire, especially in Indonesia. There were sort of, I think, 4 literal categories of belonging in the East Indies. And again, I'm using the language of the time as well. So legally, you were designated as European, as sort of mixed Indo-European or mixed race, as inlander, which is the Dutch word for native, which really meant, that was also a very racialized category. And then there was one that was like non-native, other Eastern person or something. When you create these legal categories, there are inevitably decisions made about who belongs in each category. And so you can really find these rich resources of, okay, well, how did a European court decide whether someone of mixed parentage was more European or they were more inlander, and how did they get these decisions made? And there are definitely some scholars who've argued, look, race is too blunt a category to mask onto that system. I'm not sure I'm on board with that, but I think that when you see that system transferring back to the metropole, in the case of Indonesia around 1949, 1952, when Indonesian independence came into effect and there was a lot of migration, you see race sort of coming up again and essentialization coming up again in places like the Dutch parliament, debating who really belongs in the metropole and who really belongs where their roots are back in Asia, and making these very essentialized decisions. So what I thought was interesting was how much of this de jure racialization was coming out of law schools and then coming from the same people who, after 1949, were also still teaching in law schools and still making policy. So I think that that's an interesting place to look. I think it's not the only interesting place to look. I think you could, and I sort of have been trying to define this because I'm at the beginning of my research, as time periods in which Dutch legal academia has to reckon with these changes or has to reckon with the inconsistency in teaching about kind of neutral objective law and yet being confronted by this lack of objectivity.
Yeah. Alison, I'm just going to break in there and ask Nawal, when she's not speaking, to mute her mic, because there's a little bit of feedback, and especially because we want to share this with other people. It's such brilliant stuff, so that would be great.
Okay. So I am, yes, that makes total sense. Thank you. A couple places where I'm looking so far at the beginning of my work, and this is different, I suppose, from looking at purely a legal archive in terms of law and statutes, is looking at who these people were. So a couple examples that I found so far, and this might resonate with some of the anthropologists and historians. For example, W.F. Wertheim was a colonial lawyer who worked in the colonial government as a jurist in Indonesia, or in the Dutch East Indies at the time, and actually wrote a study about how the racialized citizenship would affect what the Dutch government was then hoping would be kind of a moderated transition towards more independence for the East Indies, but a moderated transition that would still keep the Indies under Dutch control. And Wertheim basically said, look, this is really racialized. These racialized categories are not going to transition well. They just don't mesh well. And through a longer story, he's a fascinating character. He ends up in a Japanese internment camp during the Second World War, and kind of, to oversimplify it a bit, has his radicalization moment there, where he realizes that the way the Dutch are being treated in the camps is actually they're still receiving more calories a day than working Indonesians had been receiving under the Dutch regime. And this kind of radicalizes him. And when he comes back to the Netherlands, he becomes an advocate for Dutch independence. And there's this tiny line in a couple of his biographies that says his position on Indonesian independence cost him his professorship at Leiden, and his law professorship. And what he actually does is he stops being a law professor and becomes a professor of sociology at the University of Amsterdam. So his example is interesting to me because it goes back to this question of what place does critical research, or what place does contextual research have in the law faculties? It's interesting to think that this could have been a time where a sort of critical voice became part of a mainstream law faculty, and yet it didn't happen. Another example is William Lemaire. William Lemaire was born in the Dutch East Indies of, I suppose, racialized mixed parentage. His mother was considered to be native. His father, I believe, was European, considered to be European. He came to the Netherlands also, I believe, around 1947-48. He actually became a member of parliament, and he was one of the people who, during this migration, was arguing that people of Indo-European ancestry should be the ones to decide for themselves where they felt that their roots lay. It shouldn't be the Dutch government who was saying, well, if you're more European, you should come to the Netherlands, and if you're more Eastern or more Asian or more native, you should stay in the East Indies. Lemaire said people should make this decision for themselves, and he advocated for that. He was also a member of the Catholic Party, which was considered to be the more conservative party at the time. So he was far from a progressive advocate. And at the same time all this is going on, he actually does end up being a law professor in Leiden, where he teaches conflict resolution law and constitutional law. So one of the things I think is interesting, or will be interesting, is to explore a little bit more about his position in Leiden, how he was viewed there at the time, how his students viewed him. And then there was, I believe it's W.E. Korn, who was actually one of the presidents of the KITOV, the Royal Colonial Research Society, was a lawyer, the place where I now work, who also had a position in the colonies and then came to sort of be one of the forces for making this transition from colonial management to colonial study. This is an interesting theme I'm finding in my research, which is this sort of like flawless pivot of a lot of these colonial experts, for lack of a better word, who then almost immediately say, well, we have all this knowledge about the Dutch East Indies. They're not Dutch anymore. They're not the East Indies. So the immediate pivot, and I have this asterisk, goes to, well, let's put all our expertise into New Guinea, because that remains a Dutch colony until 1962. In 1962, the Dutch are forced to give up New Guinea. It's the Papua region. And then they say, you know what, our expertise, I'm oversimplifying this, but this is kind of the thread, could be of a lot of use to developing countries in Africa and Asia, which are also going through these developing and independence processes. So there's this kind of pivot to being experts on colonialism to being experts on independence and development. without any real assessment of any changes that need to be made to the legal assumptions as a result of that process. So I think that's interesting. It sounds a bit counterintuitive, I suppose, because the focus immediately stays outward. I'm questioning then what, if any, kind of questioning gets about the influence of these colonial concepts inward on the influence in the metropole. I think it's interesting to look at these places not just in curriculum, but in sort of faculty and trade publications around the time. The two big ones in the Netherlands have actually been publishing. The Advocatenblad is the lawyer's publication. It's been publishing since 1918, so it's relatively easy to go back and see what a lot of these people were writing about and saying about their opinions at that time. And also the Ars Equi, which is the publication of law faculties, has been publishing since 1951. So there are contemporaneous sources that are both sort of inside perspectives of law school, but aren't exactly coming from sort of official Department of Education studies or this kind of thing. At the same time, as you move into these, as communities, I guess post-colonial migrant communities, I'm quoting everything right now because, of course, the language is tricky and you want to get refined. As more people come from the former colonies back to the metropole, there are movements for more racial equality. There are movements for more independence, both of the countries, but of communities within the Netherlands. And yet that independence at a very surface read doesn't seem to get absorbed into the law schools. You have a lot of student advocates in 1969, 1970 saying we need to change legal education, but the advocating that they're doing seems to me at this point anyway, from where I'm beginning, to be exclusively related to sort of class and the type of lawyering that people should do to make lawyering less elitist, to make lawyers more focused on public service. I don't know the extent to which they interacted with or adopted at all any of the demands that were coming at the same time from groups like the Surinamese Student Union, who published the Rode Ster, or from groups who were advocating for more citizenship rights for the Moluccan community, which was a community that came from the former Dutch East Indies, a community that had actually aligned with the Dutch government. And then when the Dutch government gave up Indonesia, had to relocate to the Netherlands for their safety, and whose citizenship was also very contested. How were these voices getting manifested in legal education? And why does that matter? That matters because it brings us to the present day, where I don't know about the people on this call, but I have been in at least 4 or 5 Zooms since the summer about how legal education, how university education can respond to these very current movements to decolonize the university, to recognize institutional racism within higher education. So it seems to me that it's worth looking back at how we got to this place where we still, 70 years past decolonization, are still needing to confront demands for decoloniality within higher education, particularly within legal education. So that's what I'm thinking about and looking at. We have some resources that we will forward on to get put up. But I think, Nawal, unless you want to add anything, we are really curious, what you all think and what your experiences are. And hopefully we have talked a lot, but hopefully we haven't talked so much that there isn't still time for discussion.
I actually think your timing was brilliant. This doesn't surprise me, given that you both have been practicing lawyers as well as academics. Clearly, you are not yet... I was about to make a rude joke about academics and timekeeping and conference presentations there, and thinking that perhaps your lawyer side is still the strongest side.
Very old-fashioned technology. That's
very nice. But perhaps you're also showing your decoloniality and your respect for each other's time and for the desire to get more voices into the conversation, which are, of course, core principles. So in that service, I will turn to the chat. It's so wonderful. We have some comments from, I'm sorry, Mansourni. I don't know if Mansourni is your first name or your last name, but Mansourni Abadi. Thank you. And about the experience of being trained in the law in Indonesia and how much of this resonates. So I don't know if, Mansourni, you want to say something about that, but I'll bundle the questions and then invite Mansourni to speak. I had a question also for Nawal about archival research, and it's something that's been on my mind lately. I was talking with the National Archives here in the Netherlands about how structured their collections are by state categories, by legal categories, and how it's extraordinarily hard to decolonize a collection like that. And I also heard a talk from Robin Mitchell, an American scholar who's written a book called Venus Noire, who works on perceptions of Black women in 19th century France, and how it was so traumatizing to her to work in the archives where these women are categorized and you have to search through for their voices, and you see mostly the very violent things that other people have written about them. So I guess I wanted you to reflect on the nature of the archives and how it feels to be doing your work. And then Frank had a question, but I've talked a really long time, and I think Mansourni you have unmuted yourself, right? Do you want to get in on this conversation?
Yeah. So, yeah, sorry. Hello, everybody.
Hi.
Hi. Yeah, greeting from Indonesia. Yeah, it's very interesting if we're talking about the influence ducks in Indonesia, especially in our law, even in our language, and also even in our tradition. Until now, it's still strong. Until now, this influence is still strong, because in our national law, we still use from the Dutch colonial. It look like I'm not from the law student, because I just learning anthropology. So in our law, we know about the Burgerlijk's wet book. But wait, I'm writing in. Yeah, we still use until now. We still use the Burgerlijk's wet book till now. Then that's very interesting, because law student in Indonesia must learn Dutch language until until the level 2 or level 3, because they must know about the Dutch language first before they can understand our law. So until now, and even our government cannot change it. Yeah. So I think this is just my sharings. I really enjoy to, because I'm also from anthropology. Then yeah, I'm so sorry, I just a little bit shy. So ya, selamat malam and good night. Terima kasih.
Thank you.
Thank
you, and thank you for sharing. And maybe you want to join us for our Unsettling Anthropology talk a little bit later.
Yeah.
But fantastic, Mansourni, and you can mute yourself now. That feels like a horrible thing to say, but just for sound quality. And so I asked a question about the archives. I know that Frank also had a question, and I think it was for both of you, but maybe mostly for Alison, about whether there are counter law schools. For example, in the US, the Howard University International Relations School was established in the 1930s as part of the Harlem Renaissance. So are you finding evidence of sort of resistance and counter sites of knowledge in your work, Alison? And maybe while other people post their questions, Nawal with my archival question, and Alison for Frank's counter sites of knowledge production question.
Yeah, thank you so much for the question. So I really recognize what you were saying about being traumatized in the archives. That has been my experience, because the way the archive is structured is also, there has been a lot of critique on it, right? So it's also it's a state-based institution. So I use different archives. So some of the so I go to the National Archive in Kew Garden in London. But I also tried, in order to sort of balance that out, I also go to what I call informal archives, archives from the community, and I use newspaper archives. But in all of these sites, it's really heartbreaking and traumatizing to see that the voices of Black women are not represented at all. Even in the archives of from the communities that they're assumed to belong, there is also lack of seeing value in the lives of of these women. So you can find archives if they are entertainers, famous singers, actors, if they are, if they are one of the in the Black Cultural Archive in Brixton, for instance, you can find information about a lot of people in the entertainment industry, a lot of writers. You can find a lot of information, or relatively a lot, more at least, about people who were famous because they were in nursing, for instance. Mary Seacole is somebody that comes to my mind who, in an earlier period, was, but it never is the regular. Or if we talk about balancing of work and professional life, professional private life, for instance, in terms of raising kids, in terms of finding a partner and so on, you can find hardly any information. Also, in the literature that is produced, in the fiction literature that is produced in the 60s and 70s and 50s, of a lot of these were written by a lot of men from West Indies, from West Indian men or Black men who would narrate and write about their experiences and how they perceive. But there is not a lot in that period written also by women, by Black women. So I find it really traumatizing, but at the same time, I think it gives me a lot of resiliency and a lot of it pushes me, and it also I wrote together with my colleague Rebecca Franco a reflective piece about doing archival work when you're located in a legal in the legal faculty. And the different emotions that came up for both of us. She's a white scholar. I am not. So we had a lot of conversations. She's doing research in France. I'm doing research in the UK. So we had all of these. We were confused in a way, and we had a lot of discussions about, okay, what are you coming across, and what am I coming across? And one of the things that I think also what our different positionalities has produced is the fact that when I couldn't find any information about Black women, I kept on looking for Black women in the archives. So I kept on being creative, using newspaper archives, and then going back to the formal archives. I'm going to use I'm trying to find novels. Some of them are written in the 70s and 80s. It's a little bit later period, but they reflect on that time period. So I'm trying to be creative in a way in order to find these voices. And I wanted to do oral history, and I was supposed to do that in 2020. But because of the pandemic, I couldn't go back and actually interview women who were in interracialized relationships. So being creative and also being, I said traumatized, but I was also really mad because it also reflects on me as an extension of Black women obviously in a different national context and so on. But as a Black woman growing up in the Netherlands who is active in all of these grassroots organizations and so on, I also felt like, what does that mean for my future? Will I also be forgotten when I'm not around, right? As these women are forgotten. So that was also on that level on that personal level, it was really impactful. But at the same time, it is also the reason why I'm focusing on Black women. Even if I don't have sufficient archival material, I will use the material that I have by reading against the grain, but also by using what Saidiya Hartman called critical fabulation and sort of contesting fact and fiction, using that in conjunction to each other, and sort of and also challenging history as we record it in the archives, and time as we understand time as a linear something. So those are the things that I'm grappling with and trying to sort of work with the archives against the archives at the same time.
I'm glad you mentioned your article there. I was afraid you were going to be too modest that you've actually published on this very issue. I guess to Frank's question, I don't think it's unrelated. I think there are two answers. I think I always hate to reference the United States because I think I'm conscious of my positionality as an American studying in the Netherlands, coming from an American legal training, that I don't want to sort of uncritically just apply US theories to the Dutch context, especially when context is so much of what we're talking about here, historical and cultural context. But the answer is there is a lot of critical legal resistance and work and scholarship being done in the US and also a bit more in the UK, but obviously with a long way to go, as Nawal is saying. I'm not familiar with the entire law school at Howard, but I'm very familiar with the critical race theorists like Kimberly Crenshaw, like Cheryl Harris. They form a lot of the sort of theoretical bones of what I'm trying to do, and then trying to flesh it out with context-specific, Dutch-specific facts and evidence. So that's definitely how I'm approaching it. Another sort of theoretical touchstone for me is another school of thought called Third World Approaches to International Law, which basically takes the same sort of ideas that international law developed in the context of decolonization, but not necessarily decoloniality. And how did international law kind of replicate these same colonial relationships, power relationships, by framing certain issues as, well, this is a states' rights issue and you're not yet recognized as a state, uprising communities, these kinds of things. What I find really interesting is the lack of scholarship to date about those very same issues arising in the Netherlands. I think it's related to the question to Nawal because being at the beginning of my research as she's towards the end of her research, what I'm worried about and fully expecting is that when you look at higher education archives, of course, you find dominant voices. Those are the people who planned the curriculum and taught the classes and published in the journals. So I think it's really helpful to constantly indeed have in the back of your mind that there must have been resistance, and it's a question about finding it, right? That's the assumption, instead of saying, well, I'm not finding it, so it wasn't there. So I think for me, part of it is really the importance of reading alongside these legal publications, the publications from the student organizations, from the Surinaamse Student Union. I haven't looked as much into the Indonesian student associations were very strong in the pre-independence period. You see a lot of the people who became involved in the movement for Indonesian independence, the Indonesian nationalists, were in higher education in the Netherlands in the 20s and 30s and 40s. I mean, they were interacting with a lot of revolutionaries and independence activists from, Perempuan. I'm always very sensitive to my pronunciation of Perempuan Indonesia. Yes, very active at the time and obviously had publications. I have found a few things in the archive already that's like, we have all these students from Indonesia who were here on this scholarship. This is in like 1946. What do we do with them? Right? So, I mean, what happens to these kinds of these students? Did they go back? Did they stay? Did they advocate for change? I think it's really requires a lot of vigilance and dedication to put those archives in dialogue with what you're not finding and saying, why is that not happening here? Very specifically on critical legal education, I think it's interesting to look at why at this time when it could have very easily have happened here, right? You had the same sort of movements for civil rights, for lack of a better word, from communities coming from the former Dutch colonies, people coming from the Caribbean, people coming from Indonesia to the Netherlands, engaged in political movements for equality and recognition. These were the movements that started critical race theory in the United States. What happened to those movements here? There was some critical legal scholarship coming out of Tilburg. There was actually a journal, a Dutch journal, Dutch language journal called Recht en Kritiek that only published until the early 90s and then stopped. Started publishing in 1974, stopped publishing in the 90s. So I think, again, it's trying to sort of look at the empty spaces in the law school archives and fill them in with what's happening around. It's why we sort of title, context as intervention, trying to bring back the context to a lot of these discussions.
Which is a critical historical skill, actually. So the law and history are, as always, close sisters, brothers, siblings, non-traditional familial relations, however you want to call it. There are fantastic suggestions in the chat, and thank you so much, Nawal, for putting your article in there. And Alison, I would encourage you to put some of your work in there as well, if you can. We are really open to taking questions, and Remco, I see you hiding there, and also Wouter. And I hate to put you on the spot, but I do know that, Remco, you know a lot about knowledge production, and you have a big project now on knowledge production and Indonesian and Dutch intersections in that respect. So wondered if you had any questions. And then, Wouter, you were so engaged last time, and I wanted to give you the opportunity if you or anybody else had any questions. So putting you a little bit on the spot there, but
I think Remco also knows a lot about WF Airtime as well, but that might be a conversation we have offline.
Yeah. Wouter, I do have a question, but Wouter, please.
Oh, thank you. Nawal and Alison, first of all, thank you so much for doing this. These sessions are getting more interesting every time. So what I was thinking about, our Indonesian friend, let me pronounce his name correct, Mansuri, I think. He talked about the role of language, of Dutch language in Indonesian law. And it reminded me of the role that Latin has played in European law for a very long time, for centuries, based first through Catholicism that spread through Europe. And the result was that only a small elite that understood Latin, first of all, could read the Bible, so the Holy Scripture that defined much of European culture, and could read the law that also used a lot of Latin, making access to the law very restricted. And this continued after, the Latin powers themselves had retreated, so the Netherlands had become independent from Spain. This Latin still had a role, and it seems to have kind of institutionalized power over the law within a small segment of the elite that understood it, that understood how to take advantage of it, how to protect themselves with it. And I was wondering if, for example, the Indonesian government would use Dutch in the same way. And so that powers that be in former colonial empires, for example, also in Francophone and Anglophone Africa, still use those former imperial languages to secure their own post-colonial powers.
Yeah, I mean, I think there are a couple things there that are interesting to note, and Nawal, jump in. I think definitely in the Netherlands, you had to be able to speak Latin fluently to get into higher education. Is that so different? I mean, law is always a restricted entry point. It's always, you're absolutely right. Practicing it has been in the hands of the elite and those with power. That's one of the things that makes it so challenging to sort of explore it from a decolonial perspective. I think Latin is especially interesting because if you were to walk into a Dutch law school today and you were to go to a legal history class, it would almost, now I'm making generalizations and assumptions, but the vast majority of them from anecdotal evidence would still focus on Roman law and would sort of go from Roman law to the modern day, skipping over colonial law, skipping over all of these things that we're talking about exploring, sort of modern legal history. The implication being, well, the Roman law is the bones, but it also really insulates it from any sort of cultural context. So I think your comment about Latin is not misplaced at all. And in fact, the role of Roman law, the role of Roman law in regulating the law that applied to enslaved people in the Netherlands is really fascinating. And Karwan Fatah Black really explores that in his book, Eigendomsstrijd, about the with property struggle over enslaved people in Suriname. So that's a really good read if you're interested in sort of the Roman legacy there. In Indonesia, I think I'm not an Indonesian scholar, and I work with a lot of them, so I'm very hesitant to express expertise in that area. But I think what's interesting in Indonesia is what happened when Indonesia transitioned from the people who were in power immediately following independence, who were very much seeking independence from the Dutch, and I think would not have incorporated the Dutch to the coup with Suharto. And in that moment, the Dutch were really invited back because a lot of what you saw when I was talking about this colonial expertise was the study of adatrecht, which is like variously translated as Islamic law or local law in Indonesia, but was also used to create two different systems of law that applied in the colonies. So when I mentioned those different categories of citizenship, whether if you were considered European, you were subject to European law. If you were considered inlander, you were subject to adatrecht. Now, there are legal scholars at the time who said, but this is right? Because we are applying the local law to the local people. But you could also look at it and say, well, you have a segregated legal system, and there were much harsher criminal penalties under the system that was applied to the inlanders than the system that was applied to the Europeans. So when the Dutch came back in as consultants, as experts under Suharto, they brought back in their expertise on adatrecht, which was then used to sort of exert influence in different ways through the Suharto regime. So I don't think it's quite as simple as like, I don't know. I think I think the Dutch colonial relationships were used in a lot of ways, but I don't know the comment that Mansouri made about not being able to change the laws today. I don't know enough to comment on that. But I think certainly language and exclusion is a big theme running through law and the relationships with people in general. It doesn't have to be in Latin for people not to be able to understand legal language. Very often people talk about law in the language of the place and make it incomprehensible. So
there is even this term legalese.
Legalese, exactly.
Right? And the fact that even in, for example, Dutch, as a fluent Dutch language speaker, sometimes I can't understand letters I get sent by the government simply because they use terminology that no one else uses.
I'm sorry, I threw my hands in the air because I was just remembering my partner's comments when we get those blue envelopes. Everybody dreads the blue envelopes, right? Even after reading them, running them through Google Translate, trying to understand the language, it's like, do I owe money or do they owe me money? It is so unclear. And but actually, it is interesting in this respect, Wouter, because law is one very visible facet of language that alienates, right, or that creates barriers to access. And as an extraordinarily privileged person, to find yourself staring at that blue envelope with a sense of terror and horror and failure to comprehend, it suddenly gives you a whole nother set of insights into the process of legal alienation. So I think you're right, or that resonated certainly beyond your immediate comment. Is this a good point to turn to Remco's question then?
Sorry.
No, it's fine. It's fine. No, definitely. I just wanted to highlight the point that I think it connects to Wouter's point and Mansouri's point of the role of Dutch law in countries that were previously colonized by the Dutch. So if you look at South Africa, for instance, the South African legal system is based on a mix of Roman Dutch law and English law still. So even that, if we talk about decolonizing, if we look at, as I was saying, at the place, the center of power, we also have to look at what was sent out into these colonized countries and what is still remaining as the system that structures the system of law that is in place. And I don't think we could. That's why I'm always fascinated if the way the law is decontextualized, but also dehistoricized, right? So all of the sudden it doesn't exist, but then we have Dutch words in South Africa. The Afrikaner, for instance, is mix of Dutch and local languages. So that I think is really interesting to also keep in mind that the law we're now talking about here, but also how the law has traveled and how the law is also how the law still continues to work, because I feel like in countries in formerly colonized countries, not the same reform also takes place. So the Dutch law that is maybe at the basis of the systems in the colonized country, in the previously colonized countries, hasn't changed there, where the system in the Netherlands, for instance, has been going through reform. So I also think it's important to look at that.
Just a sort of tag on that one. This is how when you look back through the curriculum decisions in the 50s, or you look through these sort of like law school archives, you see a lot of discussion about whether to keep the subject oud vaderlandsrecht. And oud vaderlandsrecht, so old fatherland law, was largely kept on the books because there wasn't a law school in South Africa. And so a lot of South African students would study in the Netherlands, and I assume also some in the UK, though I'm not looking at the UK. And oud vaderlandsrecht was what they would study because that was the law that was much more connected to what was being practiced in South Africa. So even though you don't have an official colonial relationship in terms of political power, you definitely have this exchange. And again, the time period is so interesting there because you have, you can imagine white South African lawyers, let's just make that clear, being trained in the Netherlands to go back and practice law under a system of apartheid. At the same time, Dutch law is supposedly outlawing all forms of racial discrimination under constitutional and legal conditions. So it's like inserting that context has to put these things in dialogue with each other.
Any further questions? I think, Remco, you are next in line.
Thank you very much, Rachel. And thank you, Nawal and Alison, for some fascinating ideas. I'm still struggling with all the information and all the thoughts you gave me. I'll keep it very general. I saw on one of your sheets the word feeling. And my question is, how do you position the concept of feeling analytically in your research? What role does that play in your research? I'm very much intrigued by it because I'm involved in several discussions about law and legal issues on Indonesia. And I was reminded of a letter I found in the archives of a Indonesian fighter for independence, and there was an issue. There were some people were killed by the Dutch, and this person, Joop Warau, he wrote a letter and he said, "Well, you Dutch, you legalize everything. You turn everything into a legal issue, but it's not legality. Well, it is legality which is at issue here, but not according to your law." So it's the legalism of the Dutch, which is, and he was very right in saying so. It's such a strong fundament, not only of rule and of unjust rule in the colonial times, but it completely permeates the colonial culture. All the Dutch of whom I read letters or whatever really believe in this law. It's paramount. It is the ultimate source of wisdom and just rule, etc., etc. So it's so fundamental. Whereas as the Indonesians, they learned to distrust this law, and they said, "Well, you Dutch, you juridicize everything," and but that's not law. And another thing is, I was in a discussion with Lisbeth Zegveld 2 years ago, and she is of course very famous for the issue of compensation for the victims of Dutch violence in the Indonesian War of Independence, and she also is very strictly, she's strictly reasoning legally, in the sense, if you cannot bring it under the law, then we don't have an issue. So I said to her, okay, I believe in the law, but if the law is deprivileging other people, well, of course I guess you agree. Then what are we exactly talking about? And this is a continuing issue, because this I don't know whether you follow these law cases fought for the victims of Dutch violence. But it's so what is it? It's so awful what's happening there. These people are put outside of justice. Actually, the effects are very few. Okay, so sorry for taking this time. I was wondering how you position the concept of feeling in your research.
I'm going to toss that one to you first, Nawal.
Okay, so this is something I've been struggling with because there are a lot of feelings with me, with the law, with how people perceive the law, with it's, and I've been trying to grapple. So one of the things that I do is I use newspaper archives, and there are a lot of feelings in the newspaper archives, and so I've been trying to conceptualize this a little bit better. But I find it difficult as a legal scholar to legalize in a way feelings, because I don't know how to do that. I'm leaning a bit on affect theory and how, for instance, emotions come into play in cases of refugee law, for instance. Emotions, for instance, a colleague of mine, Thomas Spijkerboer, did work on LGBTQIA plus asylum seekers who, for instance, are asked to perform and show through performance of what they have, but also how they feel, how they engage, how they talk, that they belong to that specific community in order to make a claim for asylum. So those are the things that I'm borrowing a little bit from, when and how do feelings enter the domain of the law, and what kind of feelings are allowed to enter, right? And what kind of feelings are not allowed to enter. So those are the things that I work with a little bit. So I acknowledge them, and I try to make sense of them when I come across them. And I also I try to sort of highlight, as you were saying, the different positions and the different views on the law, but also on the feelings that matter and don't matter. So that's how I engage with feelings in my work.
Yeah, I think similarly, there's a lot you can unpack with feelings. I sometimes I describe myself as a recovering lawyer because I think I was so. I was a practicing criminal defense lawyer, so I spent a lot of time saying to people, "I hear your feelings, but they don't matter legally," and that is a terrible, horrible thing to say. But when you're a lawyer and you're arguing in court, you have to have material impacts, even to the extent that if you have an injury, and I'll get back to the widows in Indonesia on that fact, if you have an injury, you have to monetize feelings that were injured, right? It has to be psychological damage in the form of medical bills or when someone dies and you get compensated for it, it's not because of your feelings, it's because of lost income and things like that. So I think one of the violences of law is this negation of feelings. So that's one way you can look at it. There are a couple of articles by Nicole Imler, and I'm a terrible multitasker, so I can't put the site in the chat, but I will email them to Rachel later, who talks about specifically the cases with Lisbeth Ziegfeld and the functioning of law as public memory, which is a concept I'm teasing out from my research as well. Like, how do these post-colonial memories or colonial memories function in the space of law and legal teaching? And what she writes, and this is also echoed with a lot of American critical race scholars who write about the civil rights movement, is you can lose the case, right? The case can turn out badly, and yet there can be value in the process when it comes to things like giving a space to articulate the feelings associated with violence, even if the court ultimately disregards them. Or it can sort of create a record, even if you don't actually get recovery. So Nicole Imler writes that in these cases of the widows in the Netherlands, indeed, from a legal justice perspective, it can make you furious because the Dutch government sort of has waited until they're all so old that, there are only a few left, and then given sort of $20,000 or euros of compensation or something, and then said, now the case is closed. Legally, that seems very unjust. But she's looked at some of the community organizing that has happened around that. Again, I think bringing a larger context to those legal processes. You see that a lot in the critique of the American civil rights movement, which used legal strategies, which have you could argue have achieved very little in terms of desegregating the United States or achieving equal or equity as opposed to just formal equality. But on the other hand, served as a flashpoint for organizers that brought sort of more mainstream attention to the movement, which might have gotten us to a place. So I think it's a good ego check for lawyers to look at how sort of like lawsuits can serve various purposes beyond the actual limited justice that is achieved in the courtroom.
And Nawal, you want to add one more thing?
Yeah, quickly. I was typing in the chat, but I think also the feelings are becoming more and more relevant in legal scholarship and also in legal cases, because if you look at from the perspective of restorative justice, but also from environmental claims that don't necessarily have to do with something that can show causality or can be quantified in loss of income and so on. So I think in that way there is also development and I would definitely look at restorative justice and more claims from environmental claims.
And that is a wonderful closing comment. And sorry, Remco, I would love to give you the chance to respond, but we have 2 minutes left, and I know people have personal obligations, and we can hopefully continue some of these strands of discussion. That is the brilliant promise of this series of seminars, is that these issues will come up again and again. And I, for one, think the idea that lawyers can maybe get an ego check and be reminded to consider feelings is also a reminder to historians that once the legal process has allowed us to capture the witness to those feelings in the legal record, we can then reclaim it and use it as historians and bring those stories and feelings into public debate for possible further redress, examination, and response. And so I think, yet again, we work together with the evidence to try and bring knowledge and decolonial praxis to the world. So that is my sermon for the day, but my duty and pleasure is to thank most profoundly Alison and Nawal for bringing new knowledge to me, for sure, as Alison always does, and I'm so glad to experience with Nawal, and to say thank you to everybody for joining. Watch and spread the word on our YouTube channel, because this will be shared, and I think it's knowledge that should be shared with the world. And watch and enjoy and look out for our next event in this series. We will post it on Twitter, on the Decolonisation group. And thank you to all for being here. We will see you next time. Keep cool till after school.